This bill is not about protecting penalty and overtime rates. That might be its title, but that is not its purpose. Instead, this bill is about taking power from an individual and assuming it on behalf of the state. It's about infantilising grown adults. It's about denying workers freedom and agency. It's about substituting the uncompromising and inflexible judgment of the state for the preferences and desires of the individual. It's about attacking the independence and impartiality of the Fair Work Commission. And, Acting Deputy President, this bill is reflective of the anachronistic nature of today's Labor movement and today's Labor government. It reflects a patronising attitude that workers do not know what is best for them. It's emblematic of a paternalistic attitude that individuals should not be able to exercise their own choice. It exudes a hostility to business, especially small business, and it reveals a fundamental misconception about the nature of the economy and the workforce today. And finally, it showcases the reflective desire of this government to encroach ever further into the rights and freedoms of individuals. This bill is not about protecting workers' rights. This bill is instead about denying economic freedom and individual agency. This bill at its heart lacks a fundamental purpose. There is overwhelming support in the community that Australian workers should be fairly compensated for working overtime or in unsociable, irregular or unpredictable hours, on weekends and public holidays and so on. And the Liberal Party, and me personally, support penalty rates. But these principles are embedded right now in Section 134 of the Fair Work Act, which has as an objective that the Fair Work Commission must apply when using its powers. Instead, what this bill does is undermine employee agency, employee choice, employee flexibility. It harms productivity. It adds to the regulatory burden of business, particularly small business, and it fundamentally attacks the independence, the functions, the integrity and the probity of the Fair Work Commission. It lastly fails to strike a balance between protecting workers and preserving the essential flexibility that modern workplaces, indeed that modern workers, demand. The Fair Work Act has existing safeguards that protect the rights of workers to be fairly paid, fairly compensated, fairly remunerated, most notably the Better Off Overall test. But what this bill does is take away the rights of workers to negotiate based on their own needs, based on their own preferences, based on their own priorities. The bill seeks to create a one-size-fits-all approach. It restricts workers from entering into arrangements that might better suit their personal circumstances. So even, for example, if workers in an industry supported a change to the modern award for beneficial changes, this would not be permitted if any hypothetical employee might be considered worse off. This fundamentally removes genuine choice from employees, but it also fundamentally limits the discretion and the judgment of the Fair Work Commission. And this bill, I noticed the previous speaker referenced working from home arrangements and flexible working arrangements. This bill also creates risks to flexible working arrangements and working from home arrangements. If employers now have to start tracking precise start, finish and break times to comply, they may be reluctant to offer flexible work-from-home options, even if employees have a legitimate desire to shift their hours around in order to meet personal or caring commitments. The Fair Work Commission itself is exploring how to remove award-derived impediments to working from home, but what this bill will introduce is a potential barrier to such efforts. The reality is that the Fair Work Commission already has ample authority to protect penalty and overtime rates. And remember, there are no proposals currently before the Fair Work Commission to reduce penalty rates. The government and the trade unions that support them claim that this bill is closing loopholes, but the Law Council confirmed in their submission to the Senate inquiry into this bill that no such loophole exists. The reality is that the bill is simply a response to union hypotheticals and not real-world scenarios. In their submission, indeed, to the Education and Employment Committee of the Senate, the ACTU, the peak body of unions, concedes that it is only hypothetically possible for the Commission to leave workers off under the law as it currently stands today. And in fact, to the contrary, the judicial practice of the Fair Work Commission has been a long track record of protecting penalty rates, including rejecting employer applications to vary penalty rates when not justified by the circumstances. Section 134 of the Fair Work Act mandates that the Commission ensure modern awards provide a fair and relevant minimum safety net of terms and conditions, explicitly considering the need for additional remuneration for overtime, irregular hours, weekends and the like. All the bill does is strip the Fair Work Commission of its independence and the ability of it to exercise its functions. The bill is the government usurping the role of the Fair Work Commission by legislating specific outcomes or seeking to legislate specific outcomes rather than trusting an independent tribunal to fairly weight and moderate claims. And it repeats a pattern established by this government to reach for a legislative or regulatory solution that is not commensurate with the harm being addressed, if the harm even exists, which they do not in this case. Let me turn now to retrospectivity, one of the biggest concerns about this bill. The government has consistently argued that under the terms of this bill, if passed, will not be retrospective. But the drafting of the bill ensures that existing terms in a modern award that offend the proposed new Section 135A of the Act are vulnerable. That section makes clear that the Commission must ensure modern awards do not reduce penalty rates for any employee when they make, vary or revoke modern awards. And what this drafting means is that the Commission will have to consider these things the next time an application is made to even vary an award. It will need to look back retrospectively at what has happened to penalty and other rates in the past, even if, when looking at this variation, the variation itself does not attempt to touch penalty or overtime rates or other covered rates. And in their evidence before the committee, the Australian Industry Group, AI Group, and they weren't alone in this, say that the effect of this bill will pose an unacceptable risk, their words, unacceptable risk, to previously agreed and settled awards and other determinations of the Fair Work Commission. This bill is also at odds with all the government's talk about improving productivity in the economy. It's at odds with their embrace of the so-called abundance agenda. It's at odds with one of the supposed outcomes of last week's Productivity and Economic Reform Roundtable to declutter the regulatory agenda. What this proposal does is make working conditions less flexible, more restrictive and adds to the burden of doing business in Australia. COSBOA, the small business advocacy group, noted that this bill would be the 36th major change to the Fair Work Act since this government came to office. The 36th major change to the Fair Work Act since this government came to office. In the first term of government, this government added an additional 757 pages to the Fair Work Act. 757 pages that businesses, employers must comply with, that make the lives of not only employers but also employees impossible to navigate and manage. And this change is only going to add more dozens of pages to those 757 pages. Each change, no matter how meritorious the change might be, represents an additional burden on small business and, of course, on Australian business rather, and of course this is felt the most acutely amongst small businesses. Small businesses lack the resources to keep up with each wave of new regulation, this one being the latest. They don't have legal departments. They don't have HR departments. They don't have outside counsel. They already spend an average of 15 hours per week on compliance rather than trying to provide a service or a good to a customer. And this is all against the backdrop of additional uncertainty around existing awards, which may now risk being changed retrospectively. Acting Deputy President This bill is flawed, it's unnecessary and it's counterproductive. It will not advance workers' rights, but instead limit employee choice. It will not lead to a new nirvana for working Australians. All it will do is impose new burdens on small business. It is not going to make the life of the Fair Work Commission easier. It is going to tie their hands when making these determinations. When I think back to Labor governments of old, I recall the work that former Labor Prime Minister Paul Keating did to modernise the industrial relations system, to encourage enterprise bargaining, to strengthen the role of what was then called the Industrial Relations Commission, now the Fair Work Commission, in adjudicating disputes between workers and employees, but which fundamentally took a view that the one-size-fits-all approach, which had characterised much of labour relations in the first 3 quarters, at least, of the 20th century in Australia, was no longer fit for purpose. Paul Keating reached this conclusion in the 1980s. But what we have had with this government is to seek to turn the clock back to a period before then. The workplace has changed immeasurably since Paul Keating was Treasurer and Prime Minister. The nature of the modern economy has changed immeasurably. These days, people work from home. People work remotely. Both partners in a relationship often work. Workers have to balance caring, family and other responsibilities with their job, and modern technology has allowed them to do this. So why are we seeking to wind the clock back and apply a set of strictures and mandates and enclosures on the rights of workers, pretending that the workplace is of only one kind and only one shape and only one format today? What this is doing is winding back the clock. Further, it will hamper flexibility in our economy. It will not get productivity moving. It will add to the regulatory burden. It will add to the compliance burden. But most fundamentally, it will detract from the rights of workers, their freedoms and actions. Workers are the ones who are best placed to make an assessment about their own interests. They are entitled to bargain collectively in doing so and to negotiate collectively in doing so, but they are the ones who know whether they would prefer more flexible working arrangements, whether they would prefer to trade off higher base rates of pay for lower rates of overtime or penalty rates. They are the ones who know the demands on their time, the work tempos, the demands on their other family and personal and other commitments, and they are the ones who are best placed to make these judgments. And the existing arrangements, which allow workers to weigh all these factors alongside and with their employers across the table and make these assessments about what is in their best interests and reach a conclusion which is then upheld and can be adjudicated on by the Fair Work Commission, which will ensure that workers are better off overall, under the better off overall test. They are losing that freedom. So fundamentally, this bill is not about protecting penalty and overtime rates. It's about a transfer of power. It's about a transfer of power and agency from the individual to the state. It's about a transfer of judgment from an individual to a government bureaucracy. It's about taking away judgment, discretion, individual circumstances which characterise the Fair Work Commission's jurisprudence on this issue today. And ultimately, it will be to the detriment of workers. Ultimately, yes, it will be to the detriment of business. Yes, it will be to the detriment of the economy. Yes, it will be to the detriment of productivity. But it will also be to the detriment of workers. If you're a worker now and you want to work flexibly, you want to do clock on at 7 in the morning to do some work, prepare a submission, prepare some points, do some letters, deal with correspondence, so then you can then take your children to school at 9 o'clock, you can take your elderly grandparent to a medical appointment, or you can go and do your groceries, you go to the dentist or anything. Is an employer going to have to pay you overtime now? Is an employer going to want to support flexible working from home arrangements if they're going to have to require that timesheets be kept and they are going to have to accommodate your flexibility by paying you more? The answer is simply no. What this bill will do is deny workers freedom and choice and agency, and that is why the Coalition does not support this bill.